Hey Ram, would someone please tell the Supreme Court of India that road to hell to gratuitous occupants carried on a private car and pillion riders travelling on a two-wheeler is paved with their good intentions? On Gandhi Jayanti Day in 2022, Ram was travelling as a gratuitous occupant in a friend's private car to Tirupati. The driver lost balance and hit a roadside tamarind tree. Ram was injured. Ram lodged a motor accident claim seeking just compensation against two insurance companies, A and B, who had insured the private car on that date. The car was an year old. As per mandate of the Supreme Court of India dated 20th July 2018, A had issued a long-term motor insurance policy for 3 years. It was a package or comprehensive policy as on the date of commencement, YD Insurance Regulatory and Development Authority Circular dated 28 August 2018. However, on expiry of 1 year, the own or vehicle damage portion of the cover had ceased to operate. Only the third-party insurance cover continued for another 2 years. The owner switched to insurer B for a standalone own or vehicle damage cover, as was now permitted by a changed regime of IRDA with effect from 1st September 2019. So, on date of accident on 2nd October 2022, the private car Ram was travelling in had a third-party insurance cover alone with insurer A and a standalone own or vehicle damage cover alone with insurer B. Legally, pillion riders on a two-wheeler or a gratuitous occupant carried on a private car are covered only under a package or comprehensive policies, which protected both third-party liability and own or vehicle damage benefit. The IRDA circular dated 16th November 2009 makes it amply clear. This is where the serious problem for the likes of Ram kicked in. Owners of vehicles who were unaware of that only under a package or comprehensive policy of insurance, gratuitous occupants in a private car and pillion riders on a two-wheeler were covered and not so covered under act or liability only insurance covers, thoughtlessly switched over to another insurance company for multiple reasons. That a known intermediary as agent or broker recommended the switchover, or insurer B offered better terms for a lesser premium or price or whatever. Ram got caught in the switchover mess. Both A, who had offered only a third-party insurance cover from second year of the policy, and insurer B, who had issued only a standalone own or vehicle damage cover in second year, said sorry to meet Ram's claim. Insurers may be technically right, but it was their duty to put the vehicle owners on notice that such an eventuality may be an unintended consequence from their switchover to insurer B. Therein lies the critical folly. There are twin solutions to get over this legal impasse to protect the interests of victims or Ram's genre. One, with ourselves. As vehicle owners, we would do well not to switch over to another insurer for a standalone own or vehicle damage covers after the first year of the long-term insurance cover for the new car. We would do well to guardedly renew the own or vehicle damage portion with insurer A itself to better and fully protect our and third-party interests. Or, if we are inclined to make the switchover anyway, better to embrace the shift lock, stock and barrel to insurer B under a package policy from A altogether. That is, both third-party cover and own or vehicle damage covers. Otherwise, both ourselves as vehicle owners and third-party accidents victims would face the prospect of both insurer A and B seeking to avoid liability. As vehicle owners, we would be penny wise and pound foolish if we did not see what would come if our vehicles met with an accident and there was a third-party claim. So, as new vehicle buyers or as owners of long-term motor insurance policies, we may have to face the entire compensation payable to accident victims from our pockets. Better be aware, it is too serious to be not known or ignored. The second solution one is offering is to courts of law to consider. If and when the third-party insurance policy issued by A and standalone or vehicle damage cover issued by B are read together or in tandem, Ram and company as gratuitous occupants in a private car or pillion riders on a two-wheeler would and should be held covered or deemed to be covered by the two insurers together. The courts can safely direct A and B insurers to bear 50% liability each on equitable principles. Neither insurer would have the right to complain, as the owner and victim would have had no role in the consequences that have arisen. Neither vehicle owner nor the accident victim can be penalized on this score. Better still, IRDA could come up or should come up with an appropriate solution to protect the interests of third parties and Ram. Hey, Ram, would someone please stand up and tell the Supreme Court of India in the meanwhile that their well-intended mandate of long-term motor insurance covers for new motor vehicles may have unwittingly paved the road to hell for gratuitous occupants carried in a private car and pillion riders on a two-wheeler? Since it was the top court that mandated this change with the best of interests of innocent third-party motor accidents victims in mind, it may well be their duty to rescue us too. That is our prayer as we the people.